Good morning, and thank you for joining us today. My name is Morgan Taylor, and I'm an associate that practices employment law here at Weiss Attorneys at Law. Today, I will be acting as moderator for this webinar. Recently, the Department of Labor released some new regulations concerning the Fair Labor Standards Act. We've received many calls from clients concerning these new regulations, so our firm thought it would be helpful to review this major change to the FLSA. Today, Jim Novigrocki will be presenting. He is a principal with our firm with extensive experience in employment law. You feel free to ask questions during the presentation. There's a question box to the right side of your screen, and we'll address some questions while Jim is presenting, and other questions we'll hold till the end. If your question is not asked during the presentation, we will personally reach out to you and address the question at a later time. Jim?
Yes, great, thank you, and welcome everyone to our FLSA webinar. Here's just a sort of a quick review of what we're going to cover today. We're going to look at some changes that are happening in the law, and these are going to be your timekeeping requirements. There'll also be some notifications we're going to recommend to give to your workforce, as well as some compliance tips. And then, because the FLSA is generally divided between exempt and non-exempt employees, we'll want to review those exemptions and then kind of take a look into the crystal ball of what's going to happen once these new changes take place. Our musical muse today for the webinar would be this British band, the Rolling Stones, and what connection you're probably saying do the Rolling Stones have with the FLSA? Well, the Rolling Stones have been around about as long as the FLSA, which started in 1937. But really, we just wanted to go back to their famous song, the Mick Jagger rule about time. The time is on my side, and really, time is going to be on your side after you've gone through the webinar. Because overall, the FLSA, the Fair Labor Standards Act, is really all about time. When somebody starts work, what time they start work, what time they end work, how many hours of time they've put in a given day, and then eventually whether or not an employer would owe overtime to a non-exempt employee. And the biggest change in terms of time will take place on December 1st of this year, and the FLSA doesn't change very often. This is a significant change that in order to have an employee be classified as exempt, they will have to be paid at least $47,476 per year, which breaks down to $913 per week. And you can see on this slide the major change of that from previously. Currently, right now, a person would be exempt with only being paid $23,660 per year, or $455 per week. So it's within this range that you're going to have to give your most focus. Any exempt employees that are currently earning between the $23,660 and up to the $47, that's really going to have to be your focus, because if someone, for example, is making $35,000, then come December 1st, and they're considered exempt, then come December 1st of this year, their salary will either have to go up to the $47,476, or they are now going to be considered non-exempt, and which is going to lead you into a situation where previously the person earning $35,000, you didn't have to track his or her time and concern yourself with overtime. But after the 1st of December, that certainly is going to be something that's going to be legally imposed upon you by this change in the FLSA. Just a short note that the new salary threshold can also include up to 10% of non-discretionary bonus and commissions. So let's take a kind of an overview here of the Fair Labor Standards Act. Again, the general regulation is you have to pay time and a half for more than 40 hours per week. Those employees that qualify for overtime are called non-exempt. And the default principle here is that everybody gets overtime unless the employee is somehow exempt. And we'll go over those exemptions later. But here's your bottom line where you can see it on the result. Again, as of December 1, 2016, anyone earning less than $47,476 must be paid overtime if they work over 40 hours in a week. And the FLSA is per week. So, for example, if somebody works 30 hours in 1 week and 50 hours in the next, you have to pay them for that 50 hours. And then earning more than the $47,476, they will be exempt as long as the salary and their duties test are both met. And we're going to talk a little bit later about the duties test. So here's some of the decisions that you'll be faced with as an employer. Again, suppose someone is making an annual salary of $40,000 today. That would translate to approximately $19.23 per hour. So time and a half, takes you close to $28, $29. And so the question is, well, do I have a situation where this employee I'm willing to pay overtime, or do I increase that individual's salary to the new mark of the $47,476, excuse me. So that's going to depend upon a lot of what these individuals in that bracket who are currently, again, considered exempt but are earning below the $47,476, what do you do with them? Do you bring them up to the new salary, or are you willing to track their hours and now face overtime obligations at a fairly high amount? Because you can see somebody earning $40,000, that could be quite a substantial overtime obligation. So again, the FLSA is all about time. When somebody starts working, when somebody ends working, and ultimately, is there some type of overtime obligation? And of course, the time clock is an important part of this statute. And again, it's likely that you may have now a group of employees that, again, previously you did not have to track their time, but as of December 1st, 2016, you're going to have to track their time. So what about timekeeping under the FLSA? In some regards, the law is fairly flexible. You have to keep time of your non-exempt employees, but how you do it is really up to your own business practice and procedure. An employee could be asked to write their own times, or you can use a computer to track the end time and the start time, or any other method of timekeeping. But again, once someone is in a non-exempt category, the burden falls upon the employer to keep time. And you'll see later why that is so important, that the focus is always on the employer to keep time records. A quick overview here of what the FLSA requires in terms of record keeping. Again, for each non-exempt worker, the name, social security number, hours worked each day, total hours worked each work week, again, because the FLSA is based on a 7-day work week. And also, you can see the basis on which their wages are paid, which would generally be an hourly rate, and the total overtime earnings for the work week. So again, this may be an entirely new obligation for example, if you had a office manager who is currently earning $38,000, right now that individual will be considered exempt, but as of December 1st, that $38,000 salary would not qualify them as exempt. So that may actually change some of your payroll practices, because on that person's pay stub now you are going to have to record their total overtime earnings for a work week. Okay, so the FLSA does use some particular language about what are hours worked. And again, this law is back from 1937, so it kind of uses these phrases, well, it's either you suffer, an employer suffer, or permits someone to work. And again, the workday is measured by the time someone starts their principal activity and the time in which they cease their principal activity. So again, if someone is a finance manager and they come in and they get their coffee, well, that's not going to be their principal activity. That's not commencing the workday. It is really when they begin to sit down at their desk and begin to practice as a finance manager. Now again, the workday has to be tracked to ensure that it is in a specified period. So here's what some of the issues that employers face is really the failure to recognize and count certain hours as compensable hours. And again, it goes back to that base concept, is an employer suffering or permits someone to work? So if you look at this slide, an employee who remains at his or her desk while eating lunch and answers a telephone, that is going to be compensable time, because if that is their principal activity, then even though they're eating lunch, they're working. And those hours must be counted as compensable hours because, again, you can see the employee has not been completely relieved from duty. So there may be many people in your workforces today that, again, are exempt and are not paid for lunch, but that may change as of December 1st, 2016. So again, what we're often tracking is, in terms of overtime, it's really what somebody does before they start. If their shift starts at 9 o'clock, what are they doing before? Are they engaged in any work that you're aware of before their official start time? And then again, at the end of the day. This is going to play a big part, for example, if somebody is working from home. And when exactly do they start? And you're going to have to track that to make sure that it's clear that the work day starts at a certain time and ends at a certain time. And that may, right now you may not have had too much focus on that, but come December 1st you're going to have to. And that might, come to a point of maybe disabling computers or turning off email so you can control whether somebody is suffered or permitted to work, because you want to avoid a situation where somebody said, well, yes, I got off at 5, but I went home and from 7 to 8 I checked my email. If an employer has knowledge of that, then those could be compensable hours. Here's kind of the standard of when an employer is going to be found to know that somebody is working. And again, we're really looking at the before and after scheduled hours. Those are the times that really create the most liability for overtime pay, because you're able to track the 9 to 5, but it's really the before and after. And the courts say, well, if the employer knows or has reason to believe that the employee is continuing to work, and again, the employer has to have what we call as reasonable diligence to determine if someone is still working. So for example, if you're telling your finance manager, well, I'm expecting some customer orders from a country or a state in a different time zone, track if those are coming in this evening, then you are going to be responsible for compensating for those hours, because you, as an employer, would know, or with the exercise of reasonable diligence, would say, okay, we're getting orders in from California. We know that's going to be after 5 o'clock St. Louis time, and therefore those hours can be counted as part of somebody's 40 hours and beyond the 40 hours. And the FLSA in the case law also has this concept of constructive knowledge, meaning that if someone knew or should have known that someone was working in excess of their hours, then that can create overtime liability. Now, this becomes important because if, again, the burden is always going to be on the employer to track hours. It's not the employee's responsibility. And if an employer fails to keep records, what could happen is if somebody later sues to recover overtime pay, then there's going to be a lower standard of proof. For example, an employee may say, well, you had me working on that big project in August, and I know I worked Saturdays for a couple hours. If the employer didn't track those hours, then that testimony saying, well, I know I worked on Saturdays, that may be enough to create overtime liability and may be enough evidence to show as a matter of inference, well, I know we were in the office on Saturdays. And so that, again, always comes back to time, that as the employer, you are tracking hours. Okay, so here's some ideas that you can implement as we face this big change on December 1st. First, you have to have a clear policy for approval of overtime hours. And I would suggest that you obtain acknowledgement of that policy. A lot of employers have an overtime policy in their handbook, which is good and important. But given this major change in the law, I would suggest that you establish a clear policy for approval and actually have the employee acknowledge that. Just as you often in an employee handbook will have somebody say, well, yes, I received the handbook, I would recommend you do that for any approval policy that you're going to implement with regard to overtime hours. And you'll see why this is going to be important in a couple slides about how the law considers employer rules about overtime. I would also suggest that you determine guidelines for email use. Because again, if someone is checking their email and that's part of their principal work activity, then that can be compensable hours, especially if, again, in my example, you're saying, an employer is saying, well, check on those orders that are coming in from California. If they're going to get on their email and that's part of their principal activity, that can create overtime obligations. So whether you want to take a drastic step of shutting down email, that's a business decision, but I think that's something that has to be specifically addressed because really almost a lot of employees now have email access or can actually have it on their phones. Again, since we're coming up to December 1st, we would recommend that you publish your overtime policies before on December 1st and then a couple weeks after. This is your opportunity to really take your policies and give them life in the workplace, not just in an employee handbook, but actually a part of your workplace by, again, giving some advance warning, maybe mid-November on the actual day, since that's when the law change is scheduled to take effect, and also after. So you just have the reminders, and you'll see in a few slides why this is so important under the case law. And then if you do have any provisions in employee handbooks, now would be the time to go ahead and address those. And here's what I was referring to in terms of why it's important to have overtime rules. And the courts have reached some differing views and opinions on this. So for example, look at this first bullet point. And in this particular case, the court said, well, the employee was not entitled to unpaid overtime because the defendant had established specific procedures and the plaintiff ignored those procedures. So in that case, the court said, no, even though the person went at home and worked, they did not gain prior approval. But that was only one court decision, and there are other court decisions. Look at the second bullet point where this court said, well, just because you have a rule that says you have prior approval, that may not be enough to stop someone from getting paid overtime. And this is what the court said. Management has the power to enforce the rule and must make every effort to do so. So, for example, if you have a rule that says, well, you must get approval, and you're leaving the workplace at 5:30, and someone is still there working, and you go, hey, great job, thanks for spending the extra hours, you can't then turn around and say, but remember, you didn't ask for my approval on Wednesday when you worked till 5:30. if in fact somebody walked by and saw that employee working. So rules are important, but more important than just having the rule is enforcing it and make every effort to do so. So if there is a situation where somebody fails to get approval, then that would be the time to offer some discipline about following the overtime rules. And just in terms of your rules, not only approval of overtime, but you may want to have, consider some type of flex time. If it's really important for someone to check their emails, then perhaps you say, okay, I'm going to give you a designated 15-minute period from 7 p.m. to 7:15 p.m. to check your emails. If that's important to your business, then I think that's one way, again, to set a rule so you control the time. And that, making policies and implementing policies, that's one of the services that we offer our clients, is handbooks and how to implement a important overtime policy, because again, we can follow the case law and determine what the courts have upheld as a valid rule and where the courts have said, well, the fact that you had a rule wasn't enough. And again, that's always going to be true in these employment laws, is that there's going to be a spectrum of case decisions. And that's something that it's important for you to follow, because as in most employment statutes, the law changes all the time. And it's important to know how the courts are now construing various overtime issues. Okay, we would not wish overtime liability on anyone, and for these reasons. Overtime pay, if it's awarded, can be automatically doubled if there's a finding of bad faith. And that's called liquidated damages. If a court would find that an employer willfully, and that's the legal term we use, willfulness, that means the statute of limitations could go back 3 years. And finally, the prevailing party, if an employee does prevail, that can lead to an award of attorney's fees and court costs. Generally, under the FLSA, if an employee sues for overtime, they're able to go back 2 years. So if someone filed a lawsuit tomorrow, then they would be able to go back to September 30th of 2014. But that period, look-back period, can be extended if there's a finding of willfulness. And, those are legal concepts, what constitutes bad faith, but generally, if you look at the top bullet point, most courts have concluded that if someone should have been paid overtime and was not, it's going to be that double damages are the norm and not the exception. So that creates a larger exposure for liability. Again, if you have these group of employees who right now are exempt, but as of December 1st, if they don't meet the new salary level, will not be exempt, then travel time can be an issue. Generally, when somebody's driving to and from work, that's not going to be considered compensable time. But it's really when we get outside the commute that can create hours worked. So, for example, if somebody is going to a special one-day assignment in another city, then travel time to and from that other city is work time. Doesn't include, their 9 to 5. They're not entitled to, double time for their regular hours, but travel time can be compensable. And that might be something that, especially at the managerial level, you have not been tracking. For example, a finance manager or the office manager making $30,000 or $40,000 today might not have their travel time tracked, but as of December 1st, again, that can create a whole new obligation for you. Just a quick review again, travel that's all in a day's work generally refers to if you are a bank, for example, and you have 3 or 4 branches in the St. Louis area. If an office manager is traveling from a bank in Ferguson to a bank in Muse City, that travel time between job sites is considered as hours worked and has to be part of their computation of total hours. And again, travel away from the home community also has its own computation, especially if somebody's traveling back on a weekend, that those also can be work hours. So under the FLSA, we've talked a lot about exempt and non-exempt, and the FLSA requires payment of overtime for non-exempt employees. The one thing that's not going to change on December 1st, 2016 are what is generally referred to as the white-collar exemptions. It's the salary level that's going to change, but not these specific exemptions that have been recognized for many years under the under the FLSA. So why don't we take a little bit of time here and look over some of these exemptions, because again, this is going to be measured in your workforce, which employees are considered exempt, where you don't have overtime obligations, and which are considered non-exempt. Again, when we talk about exemptions, there's two components that have to be satisfied: the salary requirement, and again, that's the major change in December 1st, and the job duty requirements. The job duty requirements are not changing on December 1st, 2016, but as you can see, as we're going to discuss, there are sometimes gray areas whether somebody's job duty does or does not allow them to be considered exempt. Exempt employees are generally paid on a salary basis, and if someone is truly exempt, they must receive their salary for a work week in which they perform any work. So again, on a salaried employee, if they work 4 hours on a Friday instead of 8, or they work 8 hours in a given work week, they're entitled to their entire salary. And again, that kind of goes back to the whole philosophy of a salaried employee is generally going to have to work as many hours as it takes to complete the work. You also have to be careful about, in terms of deducting, making deductions from salary pay, because too many deductions, like for example, saying that, well, salaried, you took 2 hours off for the doctor, I'm going to dock your pay for 2 hours. That generally cannot be done with a salaried exempt person, because those kind of deductions jeopardize the salary basis. So you have to be very careful about how you treat the salary and deductions from salary. It's kind of a complex topic, and there's some ways you can. For example, you can substitute PTO, but again, this is an area that once you have somebody in an exempt category, then you really want to preserve that exemption by not taking steps that might jeopardize that exempt status. We've talked a little bit about job duties, and here's a kind of a general summary of the job duties in order to claim the white-collar exemption. And again, primary duty is the principal, major, or most important duty that the employee performs. And a kind of a rule of thumb in the legal world is if they're doing that greater than 50% of the time, then that can suffice to meet the job duties element of an exemption. So for example, if a restaurant manager is spending 20% of his or her time cooking and the rest 80% time of running the restaurant, then generally that 20% cooking, which again is not quite managerial, is not going to likely affect the exemption. However, if it were a situation where someone who's titled a manager gets very close to doing what you would reference as non-managerial duties. So for example, a store manager, he or she is involved in stocking inventory or unloading delivery trucks, and that's the predominant part of the job, then that title of a manager may not be enough to obtain or achieve and maintain the exemption. So that's kind of a rule of thumb, is that you have to be careful. The administrative exemption is generally one of the most complex and heavily litigated exemptions. And part of that is, if you look here at the definition of what constitutes the administrative exemption, the first part, again, they have to meet the salary, the requisite salary, but their primary duty, again, has to be the performance of office or non-manual work and directly related to the management or general business operations of the employer or its customers. And then the second bullet point is really the legal focus. Does their primary duty include the exercise of discretion and independent judgment with respect to matters of significance? Now you can see that language, and it's fairly broad. When the FLSA was created back in the late 30s, this was a little easier to determine because really the administrative exemption came out of those individuals who worked on the production line, and of course they were considered non-exempt, versus those individuals who were not in the production line and worked in an office. Well, you know, that distinction is a little more difficult today as we don't have that many places with a production line. So the focus is going to be, well, does that person really exercise discretion and independent judgment with respect to matters of significance? So someone unloading a truck generally is not going to be exercising discretion and independent judgment. They're unloading the truck. Or if someone is following a set group of procedures. Well, when the truck pulls up, here's what you do. You follow A, 1, 2, 3, 4, a checklist. That's not really independent judgment. That's following established procedures. And then it's a matter of, well, how significant are deliveries to your particular business? If that's your whole business, then it can be a matter of significance. If it's not, then that's going to raise a question about whether somebody is meeting the duties test under the administrative exemption. So here is a further part of the definition of the administrative exemption. And in terms of exercising discretion, look at this language, it's very important. Comparing and evaluating possible courses of conduct and acting on or making a decision after those various possibilities have been considered. So here's an example of someone who's considered perhaps a sales manager. And when someone calls in, they have a set price list and they say, well, here's what we're going to offer for this price, or 500 widgets will cost you this much. That likely is not going to be independent judgment because they're not really evaluating possible courses of conduct. As opposed to a sales manager who says, okay, I see what your business is, and here's, you know, they can see what their current supply is, and they can make a decision in terms of the ultimate price that's going to be charged. That is the difference, kind of a general example of how someone can look at various possibilities and make his or her own decision, which is binding. And since the FLSA will often say that a title, you know, the court will say, well, that's nice, but we don't look just at form, we want to look at substance. I would recommend that your job duties ought to be included in job descriptions. And I would give an example in your job description, just like we had talked about earlier. If you have a job description of a sales manager, then I would add that language. This sales manager position requires exercise of discretion and independent judgment in taking customer calls and making decisions as to final prices. So in that regard, you have met the job duty description. Executive exemption, again, is one of the more easily to recognize because you have to have authority to hire and fire. Generally is supervising 2 or more full-time employees and is a manager. So the executive exemption is one that's a little more easier to see because of those requirements. You generally know an executive when you see he or she. The next exemption, also the professional exemption, is another one that is a little more easier to recognize because, for example, you have a creative professional, someone who is an art editor, editor of a magazine, head of creative department, an artist. Again, those are going to generally be your creative professionals, and as long as they receive the requisite salary, then they're going to meet the professional exemption.
Okay, so I think we have a good question. Do you expect enforcement to begin immediately on December 1st, or can employers begin tracking time in early 2017?
Well, quite frankly, there are some lawsuits that have been filed that are contesting whether or not this is a valid regulation that will go into effect on December 1st, 2016. There are some federal lawsuits that have been filed in Texas, and in fact today the U.S. House of Representatives also introduced legislation to delay the implementation date of December 1st, 2016. However, given the timeline it would take to have a lawsuit go through the court system and ultimately end up in front of the Supreme Court, I think it's highly unlikely that someone's going to be able to stop this law in 60 days. However, that being said, I would continue to monitor, as we will also monitor the developments, but I would believe that your best bet is to start as of December 1st, 2016, unless the day before there's some pronouncement that the law is not going into effect, because again, it's the employer's burden to track hours. Again, just quickly on the professional exemption, generally requires an advanced degree. Accountants, lawyers are considered the professional exemption, but again, that's just with the duties test. Even a professional after December 1st, 2016, a staff accountant, for example, will have to be paid the requisite weekly, yearly salary. There's also a exemption recognized for IT professionals if they meet that salary test, and again, their primary duty involves systems analysis and the design and development of IT systems. And there's also an outside sales exemption. Again, if somebody's primary duty is making sales and they are customarily and regularly employed away from the employer's place of business, then that individual is also exempt. A slight change here is into December 1st, 2016, a highly compensated employee, someone who's paid over $134,004 per year, will also not be eligible for overtime. So as we approach December 1st, again, our recommendations are that you review your overtime policies, that you're prepared to track and record time accurately, especially of those individuals between that 23,000 to 47,000 benchmark who currently may be considered exempt, but that entire group of people may not be exempt, and that's going to require you not only to record their time at work, again, start time and end time, but you're going to have to be very careful to track, is an employee working outside of their scheduled hours. And now is the time to develop your overtime policies, because you want to get them in front of your employees. As you saw that case law slide, management has to do everything in its power to implement and to enforce its overtime policies. And we appreciate, again, you joining with us on the FLSA webinar. If there are any questions, we're certainly available at this time to take them.
Yes, so just submit questions via the messaging thing in the webinar. We have one here. What penalties might employers be facing if they choose not to comply on December 1st?
Well, then you face the legal liability if someone is technically a non-exempt employee and they're working over 40 hours a week, then you would be potentially liable for failing to pay overtime. If they're only paid for 40 hours, but that non-exempt employee is working 50 hours, then that's legal liability for that overtime pay. And remember, under the FLSA, if there is ever a finding of overtime pay due, then that amount can automatically be doubled if there's a finding of bad faith. So if someone is owed $10,000 in overtime pay, a judge or a jury could make a finding that that automatically doubles to $20,000.
Okay. So we have a few questions about policies. Would you advise that the overtime policies be separate from the employee handbook?
I don't think they would have to be separate, because then you kind of run into maybe a little bit more of an administrative burden. I think they could stay in the handbook, but as I said earlier, this is the time to kind of bring your overtime policy out into the workplace, so out of the employee handbook, even if it were just to take that page, make a PDF, send it to your workforce, again, before, on December 1st, and after, just as a reminder. And again, if you don't have a very extensive approval process for overtime, my recommendation is that you have a new policy drafted and have it specifically acknowledged, just like you would as an employee handbook. So you now know that somebody has signed off saying, yes, I'm aware that I must seek prior approval before I work overtime hours.
So just so we address this person's question, you recommend collecting this acknowledgement and having the employer keep it?
Yes. You could do it electronically, or a lot of times it's just a line at the bottom of the policy saying I acknowledge a signature and a date. But yes, I would then collect those and just have them, in someone's personnel file, because again, we follow the case law, and the courts are telling us sometimes just having a policy isn't enough. It all goes to enforcement. And I think to the extent that you can show, yes, I told these managers about prior approval, that's going to go to protect you against somebody then claiming hours after work.
Okay, so now we have a question from the employee perspective. As an employee in the R&D space who does not make the soon-to-be salary minimum, is it better for the employee to ask the employer for a raise or to keep his or her time?
Well, again, the obligation to keep time really falls upon the employer. And this, I think a lot of employers are still making their business decisions. Again, we're getting close to December 1st, but we still have 2 months. So I think people are watching. This is, again, it's a very significant change, and it's rare to have this significant of a change in a workplace law. And so I think it's going to take some time for people to figure it out, and they may not figure it out till the day before December 1st. So I think it's going to have to be a wait-and-see approach to determine what happens.
Okay, so what should you do if employees are making work calls after hours, even though there is an employment policy against that practice?
Well, I think part of it is, why are those calls being made? And have you addressed that in terms of prior approval for overtime? And we kind of talked about that a little earlier. If there are, in fact, customer orders coming in from California that you need to get those orders, then it may be worth having somebody work a little bit after hours in a very defined workspace. But otherwise, then I think you're going to have to, maybe once pay it, but say, okay, you saw the prior approval. If you don't follow this prior approval process again, then that could lead to disciplinary action. And again, that's why I think it's important to start not just not just keeping your overtime policy in the handbook, because people may or may not see it. Bring it out of the handbook and do it before December 1st, on that day and after.
Okay, so I think that's all the questions we have right now. If you have any questions or think of any questions at a later date, You see our contact information up on your slides. Given this litigation moving through the courts, we'll be continuing to monitor the rules and any changes that are coming through. And we'll try to keep you updated via our website, our blog, or any newsletters from our firm that you might be signed up for, whether they're digital or in paper form.
And if you're ever, kind of at a, what to do next, you can either call us or always be able to hum a Rolling Stones song. Time will be on your side. Great. Thank you so much for joining in with us. And we appreciate you taking time out of your important days, and we appreciate the opportunity to be of service to you. Have a great Thursday, folks.